Janine, are we okay to start just because it's just a workshop. That's interesting why is that unusual on an ACL? All right. We're reconvening. Sorry to be a little bit late. It is 1:08. And we will reconvene for the workshop on item number 9. Mr. Howard, Mr. Wiles, who's...
Yes, this is, thank you, a workshop item on a ACL against California Department of Transportation and Confusion Hills in Region 1, and Phil Wiles is going to be presenting.
Good afternoon, Chairwoman Marcus and members of the board. Phil Wiles with the Office of Chief Counsel. I know you were probably expecting to see Senior Attorney Bethany Payne presenting this item today. Unfortunately, she took ill late last night, and so I will say this, she does still deserve all of the credit for the hard work that went into drafting the order and wading through the record from the North Coast Regional Board. This is just a workshop item to receive comments on a draft order that was circulated to the parties in early December. I will note that a revised version of the order was subsequently sent out to the parties after we realized that we had been relying on a version of the North Coast Board's order that was posted on their website, but was actually not the final version adopted by the board itself. They did make some revisions between when they posted theirs and adopted it. So we've done some repagination and carefully tracked the changes between the versions we were looking at and the version the North Coast Board actually did adopt. Those changes are reflected in a revised order that was circulated to the parties on December 19th. I'm going to recommend just two very, very minor additional revisions as a result of the comments that we received from Caltrans. I can read those to you in a moment. I also wanted to offer to the board, depending on your pleasure, the order goes through the background, discusses the issues that were raised in the petitions. I could summarize those for you if you like, or if you prefer, we can wait to hear from the commenters and then I can handle whatever questions you might have. I'll look for some direction from the board on that. And so why don't I go ahead and tell you what those two minor changes are that I'm going to be recommending. Again, this is not for voting today. This will be brought back to the board next month for adoption. I'm assuming next month, depending on the scope of any changes the board might give us in terms of direction today. The first revision is on the draft order at page 8. And in the very first sentence at the top of page 8, the draft order states, after an introductory clause, that the department never specifies which violations in the ACL order it is challenging for improperly relying on the reports or photographs. This entire paragraph is really something of an aside. This is, as you know, we're digging somewhat into the weeds in terms of evidentiary objections and evidentiary rules. We don't want to quibble with the department over whether or not they specifically identified the violations or not. So I'm going to propose that we change the last part of that sentence. And so it would be striking the words violations in the ACL order it is challenging for improperly relying on the reports or photographs, retaining the footnote, but inserting in its place the words objections continue to apply to the violations that the North Coast Water Board ultimately assessed against the department. Because the point really in this paragraph is that they provided quite a large number of objections to the North Coast Water Board, And to the North Coast Water Board's credit, they took that information under careful consideration and actually revised and reduced the number of violations that they found that Caltrans had committed, and also reduced the amount of liability that it was interested in assessing against Caltrans. And so this paragraph really is about the fact that Caltrans, rather than being more targeted as to the violations that were actually ultimately assessed by the North Coast Board, they really just incorporated by reference the arguments that they had made, in some cases, again, successfully, to the North Coast Board. Again, this is all in the nature of an aside. It's not critical to the holding of the order at all, but again, we just didn't want to argue over how, the level of specificity in which they were complaining about the violations in their petition. The second change is even less significant, and this is on page 11. Again, this is responding to the comments that we received from the Department of Transportation. In the last paragraph on page 11, starting with "of note," the draft order reads, "Of note is the fact that the department itself also relied on the content of these biological monitoring reports during the hearing." Their point is that they didn't rely on them, but the record does clearly reflect that they did use those reports, and so the proposal here is to strike the words "relied on the content of" and replace it with the word "used." Again, not central, but we're not interested in arguing over exactly how they used those documents. A conforming change would be 2 lines below in the sentence that starts, "regardless of whether the official records or business records hearsay exception applies, the department's reliance and use of the materials." We would just strike the words "reliance and." So we would read, "The department's use of the materials supports their trustworthiness." Those are the only changes that staff's recommending to the revised order at this time. Certainly, if the board has questions or would like to give the staff direction in terms of other changes you'd like to see, would be more than open to hearing that today, so that we can go back and, as necessary, make any changes before we present it to the board for adoption.
I know I know there's some people who need to leave, but can you, and the people who are here following this are probably people who are very well aware of it, but just for folks who are listening, good government, can you just give a 5-minute or less why we're here intro, and then we'll go straight into the comments and go from there.
Absolutely. So the board is considering this under its authority under Water Code Section 13320. The North Coast Water Board issued an administrative civil liability administrative civil liability order to the Department of Transportation for violations of both a Clean Water Act 401 water quality certification and the Caltrans statewide stormwater order, municipal stormwater order. These violations were related to a very significant construction project that the department and its contractors were undertaking on in the area called Confusion Hill, which is, I believe, a sort of an entertainment stop on the South Fork of the Eel River in Mendocino County. Again, a very significant construction project. They were building a couple of bridges, new bridges, across the river, and the North Coast Board, after a full day of hearing, assessed a liability against the department in the amount of $475,000. The department and its contractor, MCM Construction, both filed petitions with the State Water Board to review the administrative civil liability order. And I can run through essentially what the issues in the petitions are. With respect to Caltrans, they asserted that the the liability amount should not include an assessment for staff costs. Their view is that staff costs are not authorized by statute to be assessed. The draft order concludes that yes, indeed, under a water quality control policy adopted by the board first in 2002, the board has interpreted the relevant statutes to authorize the assessment of staff costs. In this case, the staff costs were clearly within the maximum statutory liability, and in fact the board declined to assess the full amount of staff costs, which would have been somewhere in the nature of $300,000, because they felt that the department wasn't on proper notice that after the complaint had been issued that the staff would continue to incur costs and that those costs could also be assessed against the department. The second issue that Caltrans raised, this is in the nature of evidentiary issues. They essentially challenged the admissibility of the evidence that was used during the North Coast Board's hearing, primarily with respect to reports done by biological monitors and photographs contained in those reports. And the order explains how these pieces of evidence actually are admissible. We have lower standards in administrative proceedings than the courts do, so we don't apply the technical rules of evidence, but nonetheless, the order does walk through how the reports themselves survive a hearsay exception, survive a hearsay objection, and how the photographs would survive objections to foundation and authenticity. I will note that we went through, and although the order doesn't discuss this, virtually all of the objections based on hearsay that were raised in the petition, there is additional evidence that corroborates those violations. And then the last issue that was raised by Caltrans was they pointed out that the North Coast Board's prosecution team had actually withdrawn a number of violations, most of which had been taken out of the administrative civil liability order, but there were 3 that were left in inadvertently that apparently nobody picked up when the North Coast Board adopted the order. And so the draft order does actually remove those 3 violations, and the North Coast Board agrees that that's appropriate to do so. With respect to MCM Construction, their petition challenged 7 of the 9 different categories of violations that were assessed. You might wonder, I should explain, why does MCM Construction have an interest in this? Well, they were the contractor. Although the administrative civil liability order was assessed against the department, it's quite conceivable that MCM may have some liability to the department to the extent that that they determined that the violations were actually the responsibility of the contractor. The 7 categories that they are challenging, those include categories of violation related to construction dewatering, leaky equipment, discharges of turbid materials, insufficient measuring of turbidity, discharges of cement or other materials, stormwater permit violations, and then a few other violations that don't fit any particular category. MCM also challenged the way in which the North Coast Board considered the various statutory requirements in determining the amount of liability that should be appropriate. In essence, the North Coast Board looked at those factors from a holistic perspective as opposed to applying those factors on a violation by violation by violation basis. The draft order concludes that for those categories of violations that there is, in fact, sufficient evidence in the record to show that the violations did occur, and that the North Coast Board appropriately analyzed the statutory factors in arriving at an appropriate assessment in terms of the amount of the administrative civil liability. We also received comments on the revised draft order from the Association of General Contractors of California. Their comment letter essentially points out their perspective that many times when it's a best management practices based approach to compliance, that oftentimes the first effort may not be sufficient to achieve complete compliance. We certainly don't disagree with that. In fact, the record reflects very well that the North Coast Board took that concept very well into consideration and actually chose not to assess liability for a number of violations where, although the violation did occur, it was clear from the record that either Caltrans or MCM or both were trying to go through a process where they would try a best management practice, and if it wasn't successful, they would promptly try something else. And so the good faith efforts, if you will, of Caltrans and MCM were fully taken into account by the North Coast Board. So in essence then, the draft order upholds the North Coast Board's issuance of administrative civil liability against Caltrans. It does remove the 3 violations that were an oversight. It also does one other thing, which is it correctly applies those the liability amount to the appropriate fund administered by the State Water Board. This is probably not something that most people care about, but we actually have 2 different funds that receive our administrative civil liability amounts, the Waste Discharge Permit Fund and the Cleanup and Abatement Account. Mm-hmm. And the draft revised order takes the opportunity to ensure that the correct amount goes to each fund. And I'm afraid that's probably more than 5 minutes, Chairwoman Marcus.
That's helpful overview for anyone listening who's not already deeply enmeshed, so thank you.
Sure.
It was very well done. All right, let's move right along to the discussion, and we'll see where we are. Mr. St. John, welcome back. This is your day.
My day. Good afternoon. My name is Matt St. John, Executive Officer of the North Coast Regional Board, and I can assure you my comments on this item are going to be significantly more brief from this morning's comments. I'm here to represent the North Coast Regional Board on this item and to express our strong support for the draft order in its entirety, including the proposed changes that Mr. Wiles outlined. We appreciate the State Board staff's careful review of my board's action, and we are pleased that the draft order upholds the ACLC that my board implemented. That's all my comments. I appreciate your taking this item up. Thank you.
Okay, thank you. I know you can stay with us a little while longer, so let's see. Next card I have is John Cooper, Regional Manager of Associated General Contractors.
Good afternoon. Like you mentioned, I'm John Cooper with AGC. AGC is an organization composed of nearly 600 contractors and specialty contractor members throughout California, and more than 400 associate companies and firms that support California's construction industry. AGC is particularly concerned over the rising cost of construction in our state. We're also concerned with the industry's need for consistency and predictability in the regulatory environment. Contractors must be able to rely on their permits. We're concerned here that the precedent may be set which would disrupt a contractor's ability to rely on permits issued by regulators. AGC sees a significant problem in contractors if contractors cannot reasonably foresee how regulations will be applied and enforced against them. Without consistency and predictability, the cost to contractors and taxpayers for necessary projects in the state will continue to rise. We thank the board for its time and respectfully request the boards reconsider its proposed order. Thank you.
Thank you. Any questions? Thank you, Mr. Cooper. Ardeen Zazaron from Cal DOT. And the perfect. Hi.
Good afternoon. I am Ardeen Zazaron. I'm here representing the people of the state of California, acting by and through the Department of Transportation. Initially, I'd like to introduce a couple of representatives of my agency. If you gentlemen could stand up. Mr. John Rodriguez, he is the Chief North Region Construction. He's here from Marysville today. And to his right, our left, is David Melendrez. He is the office chief for, he's actually our NPDS program manager, office chief environmental engineering down here from Eureka.
Sorry I couldn't get you all back out by lunchtime. I tried, but I didn't.
They enjoyed the cafeteria sandwiches, so they're happy to be here.
It's not bad.
I will just say that the first alleged violation that occurred in this case happened in 2006, and here we are in 2014. I'm very reluctant to prolong this any further, so my comments are going to be very brief. I will say that, Mr. Wiles, I commend you for encapsulating this matter in a very succinct and brief way. I'm just going to add a couple different factual things to what you already told us. As Mr. Wiles mentioned, this was a project to basically bypass 101 in an area of very northwest tip of Mendocino County. There was some amazingly disastrous, I mean close to disastrous landslides that were occurring up there on 101. It was endangering motorists, endangering the Eel River, and so this project was to bypass that stretch of roadway to get folks on two different bridges. If you've never seen it, it's really quite a beautiful setting, and the bridges are actually quite gorgeous themselves. So successful project in the end. The department did concede about 20 violations during the course of the proceeding. There was no question that early on in the construction project, there were some problems, some oversights that were addressed. Clearly the department did recognize that there were problems. However, as the case went on, or as the project went on, the record shows that the problems minimized, and we consider it to have been a very successful undertaking. Ultimately, of only 25% of the charges, monetary-wise, that were alleged against the department have been upheld. So why are we here? It's because we continue to take the position that staff or costs in general, and particularly fees, are not allowed unless the legislature says so. We are agencies, we're creatures of the legislature. We only have the powers that we are expressly given. The enforcement policy here at issue relies on Water Code 13385, which says not a peep about costs or fees. In addition, the enforcement policy itself is not, we've argued that it's, at least the cost part is not embodied in a regulation. So we are concerned that we could have been exposed to $300,000 of fees, basically staff fees, without any authorization for that. Assessment-wise, we were assessed I think it was $76,000. And and I would also note that that amount represents 100% of what was sought in the complaint, even though only 25% of what was sought in the complaint was actually found in terms of liability. So there's somewhat of a disproportion there. All the parties have had to bear the costs of their own defense. Many of the charges were found to lack sufficient evidence. We think it's not just to assess costs when they're not allowed by law, and also if they are going to be assessed, that they should recognize the ultimate liability that's been found. The department, notwithstanding some of the proposed changes to the draft order, still maintains its evidentiary objections, and I will not bore you by repeating them all here, but for now, I think I'll close my comments. Thank you.
Thank you. Next, we have Sean Hungerford from MCM Construction.
Good afternoon, Chair and members of the board. I actually have a PowerPoint presentation.
Okay.
Lift it up. We do have a PowerPoint presentation. I don't know if it's up. We just have a few slides that we had for reference.
Great, yeah, we see it on our screens right here.
Helpful. Thank you. So my name is Sean Hungerford. I'm representing MCM Construction. MCM, for those not familiar with the company, is one of the leading bridge builders in the state. They're a specialty bridge contractor with experience building bridges over water construction. They've been building bridges for about 40 years, built thousands of bridges during that time, including several bridges in the North Coast region that preceded this one. Those bridges were built under 401 certifications that were very similar to this one, and those went off without any problems. So I think it's important that everyone know at the outset that we're talking about a contractor who has quite a bit of experience actually building bridges in the North Coast region with familiarity with the agency's requirements. What's troubled MCM about this particular project and the ACL penalties is there seemed to be a fundamental departure between what the North Coast region had applied in terms of their 401 certifications on prior projects, and this one in particular. So we wanted to take the opportunity today, not to get through all the details because we know there's a lot of big record, there's a lot of hair, so to speak, on this case. We wanted to focus on the macro issues, the thematic problems that we have. And the question was asked earlier by Mr. Wiles, why is it that MCM would be interested in this? I think because this type of case has a precedent for bridge builders and other large contractors in this state. I think it's important that these issues, which are more policy issues maybe than kind of the nitty-gritty of the evidentiary questions and all that, I think these are appropriate issues for the State Board to address. And so the first issue is just the issue of turbidity. Now, it was abundantly clear to everyone in the process that we're building a bridge in an active river, there will be turbidity. That was something that was stated in Caltrans' application to the Water Board for the 401 certification. It was something that was recognized in the certification itself. In the final analysis, it also was clear that the nature of the turbidity in this project was exactly the type that was contemplated in the application. But I'll linger on that for a moment. I'm actually going to advance a couple of slides because I want to point something out. So what I have up now is an image that we showed during the North Coast hearing. What we have is a number of foundations that have been installed in the river, and then in red, a number of foundations that were actually contemplated by the application to the regional board, but weren't installed in the river. And the difference is fairly dramatic. We have from 6 live piles actually installed in the live river to 50 that were anticipated. And what happened here essentially is Caltrans and the contractor got together, they looked at what was approved, and they decided that there was a problem here. That this was the plans going into the project were the type of plans that were going to produce an inordinate amount of impacts in terms of turbidity, discharges. And so they revised the project design to avoid much of the in-stream work. One other point. The project also contemplated access down into the river canyon. What we have is a fairly steeply incised canyon in this part of the river. And so as far as getting vehicles and equipment and men down to the river, the initial plan was we'll build a giant ramp, which of course would require us to mound up thousands of cubic yards of material so we could have that ramp built down in the river. And there's a low river crossing. Again, major problems with permitting, major problems with impacts. This was something that was in the application that was contemplated when the regional board issued its 401 cert. But in the process of construction, MCM was able to avoid these impacts entirely using a process of actually lowering equipment and vehicles with a crane from the false work you see behind you in the image. So at the end of the day, we have a situation where an application's been submitted, anticipates impacts, a certification's been issued that understands those impacts will take place, and because of changes made by the contractor and Caltrans, what was going to be this level of impacts is now down to here. So with that in mind, I think MCM looks at this in this way, that there's a fundamental disconnect between what the final order states in terms of issuing hundreds of thousands of dollars in civil liability and what actually took place in terms of the construction and the efforts to reduce the overall amount of impacts on this project. And we think that there's a role, there's a space in the overall ACL calculus for these things to be taken into consideration. And we don't feel that that was done didn't go as planned. Let's see. Here we go. Can we bring it back? There we go.
Oh, that's
Second issue, and this is the issue of best management practices. So the 401 certification here said, like many certifications do, that adequate BMPs, best management practices, we put in place. Didn't define what those are, and frankly, for a project like this, there's nothing in Caltrans BMP manual says exactly what you're supposed to do. But Caltrans, being experienced in this area, MCM having a lot of experience building bridges, there's techniques that they've used and developed over years and years of building bridges that they employed on this project, specifically to install the foundations. Here we have 6 foundations that look like this actually installed in the live river. Of those same techniques, 5 of them worked perfectly. With one of them we had a problem. We had some turbidity, and there was a penalty of $10,000 issued for that. But one thing that strikes us in this particular violation, which I think is illustrative of many of the violations in this case, is that the focus on the regional board appeared to be on the fact of turbidity, not whether or not the best management practices were adequate. There was virtually no evidence put forward on the issue of BMPs. Was there anything wrong with what MCM had done, all the techniques they employed to minimize turbidity, from the sandbags and the filter fabric? There was no consideration of that at all. And we think that that's a failure of proof on the part of the regional board and an absence of evidence and record to support the ultimate order. One thing that just strikes me before I move on is that this is a situation where MCM and Caltrans had a number of experts that they brought to the hearing with them. As you might expect, because it's a complicated matter, we're building a bridge, there's a lot of technical and civil engineering expertise that's involved in that. And so we put on those experts because we wanted to say, no, this is how you do it. These are appropriate BMPs for this situation. And I just want to note that the regional board's prosecution team did not have any similar experts. All of that testimony was unrebutted. Now, I don't mean by that to advocate that every time a regional board has to put on expert testimony, right? But on an inherently technical engineering issue, I think that when you have a certification that gives it to the contractors and to the permittee to devise best management practices, because none are actually stated in the permit, and they do that using their best professional judgment, then I think that some credit, some deference has to be given to those, unless there's contrary evidence in the record to the effect that those BMPs were not adequate. And we don't think that there's that such evidence exists in this record. And finally, there's the issue of the terms of the certification, and specifically we'll just focus on the requirement that the disposal be to dry land rather than to quote-unquote surface waters. I think the facts on this particular point are pretty clear. We had an application submitted by Caltrans that was very specific that the project would be installing a sedimentation basin on the gravel bar next to the river. Regional board staff looked at that. They had no trouble with that at all. They actually had some pushback on some other issues, but not on that. And so when this 401 certification was issued, it was reasonable for Caltrans and the contractors to believe that that had been approved, that that was acceptable to the regional board. Since that time, there's been what we believe is an after-the-fact interpretation of this particular provision of the certification, that the requirement of dewatering to dry land rather than to surface waters is something that wasn't met here because we were below the 100-year floodplain. And I think what's important for the state board to understand is that's not part of the record. That, in my view, and I think MCM's view, is another after-the-fact interpretation of what this language meant. It's very clear from the record that this plan for dewatering was put forward to the regional board, that they approved that without any stipulations whatsoever. And then Caltrans and the MCM did virtually exactly what was anticipated in the application. And so with that, I think those are the main issues that we wanted to bring to your attention. Obviously we have read the proposed order. We're not in favor of it. I would hope, and we would hope, that the state board would consider these things and to reconsider. Thank you very much.
Great.
And any questions?
Thank you. That was impeccable timing. That's good. Thank you. Mr. Wells, anything you want to clarify? I mean, so far these comments are very helpful in telling us where to really focus our reading of all of this stuff, and we will take it all in very seriously before it comes back to us. But what else do you want us to be thinking about?
You know, this is really, if you have questions based on what you heard or what was in the written comments, I'm happy to try to answer them. If you'd like to talk about the specific violations that Mr. Hungerford referred to, I'm happy to talk about those. There is evidence in the record on the footings about, you know, I think in the previous item, a picture tells 1,000 words. Well, in some cases, a picture doesn't tell 1,000 words. And in that particular situation, the assistant resident engineer for Caltrans actually cited MCM for having turbid discharges from those footings, the same violation that Mr. Hungerford was referring to. I can offer that our practice historically has been to avoid specifying the precise best management practices unless absolutely necessary to do so. We don't pretend to be expert. We instead set in our 401 certifications and in our permits, we generally set performance standards that have to be met, and we leave it to the dischargers to determine how best to meet those standards. The last thing I'll say is these arguments were all made to the North Coast Board. The North Coast Board found some of them to be compelling and changed the administrative civil liability order from that was proposed by the prosecution team significantly due to these types of arguments that were made. The state board's role traditionally is not to dig, you know, as long as there's sufficient evidence to support the violations, and as long as there wasn't any procedural error created by the regional boards. The state board generally does not choose to dig deeply into the specifics, but if the board wants to in this case, by all means, I'd be happy to hear that direction.
Yeah, it's not so much a direction comment, but you know, when we were looking at the gravel bar and all that, you know, those of us with some technical background know a gravel bar is part of the water body system, and there's underground flow. However, you know, there were some conditions of the 401 that had, as I understand, a certain setback, but Mr. Hungerford brought up that there was some type of authorization, and yet it seems to me like it's a fairly straightforward distance calculation where this was within the agreed setback of the conditions of 401.
Right. So this particular violation for the settling basin on the gravel bar. Well, the first issue is the certification condition was that there not be discharges to waters of the state, not surface waters, but waters of the state. The gravel bar is clearly an area that is underwater during times of the year, certainly within the banks of the water body, and no question in our minds that that's considered to be within the waters of the state, even if it's not wet at the time.
Mm-hmm.
But probably wet, not far below the surface, and a very porous geology.
I believe the North Coast Board felt the same way. Yeah. The question about the distance, the condition was that there not be discharges within 100 feet, and this settling basin was, I believe, 70 to 75 feet away from the flowing water body. The argument here, again, I probably shouldn't get so far into the weeds, but the argument here was there may not have been a suitable location that was at least 100 feet from the flowing water body. Part of what the North Coast Board considered was that nobody had asked for relief from that provision. They just went ahead and dug the sedimentation basin where they could. I'm not going to be able to tell you what the North Coast Board would have done had they asked for permission and it had been granted. But clearly, I think the North Coast Board felt it significant that given that circumstance, there was not an effort to relax that condition or get staff to affirm that it would be okay.
And just one other issue, the recovery of staff costs. I have experience. In the '90s, I was at staff level, and then I was on the regional board at San Francisco for 4 years. And staff costs are always, or if almost always, taken into account in enforcement orders and part of the enforcement policy. So I mean, this is to me kind of an outright challenge to some fundamental practice of our agency, and yet there seems to be a rationale within 13.385 that that we're using. And do you care to maybe elaborate on that a little?
Sure. So as the draft order explains, one of the statutory considerations that the water boards are supposed to apply when determining the amount of liability to assess is a catch-all phrase that's phrased as other factors as justice may require. And the state board...
Now that's the quote of the day.
Oh, thank you. The state board has interpreted that through its water quality control policy, the enforcement policy, to include how much effort was expended by staff in bringing this set of violations to the appropriate board for enforcement. And I think probably the real confusion here is that although it was not adopted as a traditional regulation under the Administrative Procedures Act, it was adopted under the board's special provisions for water quality control plans and policies. It's essentially the same approach that we use for all of our plans and policies under Government Code Section 11353. It does absolutely serve as a regulation, and there are cases that hold as such, but it goes through a slightly different process, and therefore that may be the source of the confusion.
Thanks for the explanation.
Other questions?
I want to make sure I understand the pilings, BMP, and turbidity. The standard is a BMP, but it's performance-based in that as soon as a certain amount of turbidity exists, the standard has been violated? What is it tied to?
Sure. So this particular violation that was identified on the slide as violation 75 was for causing a turbid discharge to waters of the state. And that was the standard that the North Coast Board found was not met, was violated. The question about what BMPs, what best management practices a discharger uses to meet that standard, Mr. Hungerford is correct. We traditionally leave that to the discharger to determine what is the best way to avoid having a turbid discharge. In this particular violation, the facts that the North Coast Board considered included a report from Caltrans saying that that the contractor did not have a good seal around essentially the area where they were placing the concrete, and as a result, the concrete escaped, leaving a plume in the river approximately 150 feet in length. That's the violation, the discharge that resulted in turbidity to the flowing water. That's the particular violation that Mr. Hungerford was referring to that the North Coast Board.
So it's not strict liability in that as soon as there's turbidity, there's a violation. It's that there wasn't a seal and the BMP was not followed or wasn't implemented.
Well, I will say this, that under this particular statute, Water Code 13385, it is essentially a strict liability standard, but the important part to consider is that this is not a mandatory penalty. And so the North Coast Board used its discretion for a whole slew of violations, well over 100 violations, to determine whether or not to assess liability based in part on the severity of the violation, based in part on the gravity of the violation. So it had the ability, and in fact it used that ability to determine which violations were serious enough to warrant an administrative civil liability and in what amount.
Good, thank you.
Can you address the predictability issue? And I'm loath to say, in some ways it sounds like, I don't want to put words in your mouth, like the argument is that if the North Coast hadn't enforced on something like this before, it's somehow wrong to enforce it now, which would be like saying that the North Coast had to be everywhere and always on everything predictably. At least that's how I heard it. And yet I understand the desire for there to be more predictability. And so are you just saying that in this particular case, North Coast went and the board used its discretion to limit everything that was found to things they thought rose to the level that they needed to do something about, based on what they generally see? Because we don't have enough enforcement folks. I'm sure things happen we don't see, so you wouldn't hold us accountable for not being everywhere all the time. I'm not saying that well, but I'm just trying to figure out how to understand the predictability argument when we can't either tell people exactly how to, if we told people exactly how to do things, I suspect that engineers and contractors would take a front, wouldn't they? They would say, because what I've heard for 30 years is just give us standards and we'll figure out how to meet it.
Right. No, I think your characterization is a fair one. And maybe this is something that the North Coast Board Executive Officer would like to speak to, but I understood it to be essentially, we might have done things like this in the past and didn't receive any enforcement for them, so it's not appropriate for you to take enforcement now. Those were arguments that were made to the North Coast Board. Frankly, in our review of the petitions, we focused on whether or not there was sufficient evidence to support the violations, and we did not try to go back to look at a past record of whether or not, to the extent that such a record even exists, a past record of whether or not perhaps other boards or a previous version of this board had been more lenient in terms of enforcement.
All right. Any other questions? All right. Then as this is a workshop, I just thank you for your time. That will help us as we focus between now and the final hearing on this matter. Thank you for coming, and thanks for staying all morning, early afternoon. All right. Item number 10. Mr. Howard.
Excuse me. This one is on our statewide sanitary sewer overflow reduction program. We do an annual compliance report for the board to describe how we're doing in this program, and Victor Lopez is going to be the main person presenting, and he can introduce his other participants.
Hi, good afternoon. Actually, this is Diana Messina. I'm the chief of the surface water permitting section in DWQ. And I'm going to be introducing Victor Lopez, which is here. Also, we have his senior, Phil Iserina, and we have Russell Norman. These are the sanitary sewer system staff in your Division of Water Quality. The reason I'm introducing them is because this subject is very similar or overlapping to the information item in your item number 13. And so we want to make sure that the discussion doesn't get confused.
Is there a reason why they weren't one after the other?
Probably.
I mean, our brains can handle going back and forth a little bit, but I'm just curious if there was a method to the order. You can do them together if you like. I mean, you could do 13 next if that helps. It's up to you. We'll be here.
Okay. Actually, I think that would help. So thank you. So for this presentation, Victor is going to be going over the statewide sanitary sewer system waste discharge requirements, and he will show you the data and the trends that have come forth from the information. He'll go over the compliance and enforcement that takes place in this program, and then I will touch on where we go from here. And if you would allow us to go straight into agenda item 13, we're going to continue the discussion of the overflow requirements from the regional water boards and more staff recommendations and conclusions. Okay, so thank you. Here's Victor.
Thank you, Diana. First, I'm going to start with the basic requirements of the statewide order for sanitary sewer systems. And if you have any questions as I go through my presentation, please let me know. The statewide order regulates publicly owned sanitary sewer systems that own a mile or more in pipe length. However, this order doesn't regulate wastewater treatment plants and combined sewer systems. This order requires that all sewer overflows be reported to an electronic database, regardless of the volume. And we currently have 1,093 publicly owned sanitary sewer systems enrolled in the program. These enrollees are required to complete a sewer system management plan, which essentially is used to manage their collection systems more effectively. Moving on to some data that we have identified over the past fiscal year. There were, out of the 1,093 enrollees, 45% reported one or more sewer overflows to the database, and the remaining 55% did not report an SSO to the database. This doesn't mean that they're not in compliance with their monthly reporting. As part of the requirements, whenever an enrollee does not have an SSO or a sewer overflow, they're required to submit a no-spill certification for any given month. During the past fiscal year, 4,840 sewer overflows were reported to the database, and out of this, 60% reached surface waters. In terms of the volume spilled, 9 million gallons of sewage were spilled, and 66% of that volume reached surface waters. In terms of trends that we have identified in previous reports that remain unchanged, we identified during the past fiscal year that 91% of all the sewer overflows reported to the database were less than 1,000 gallons in volume, and they contributed to about 5% of the total volume in the state. And the leading causes for this small volume SSOs but high frequency are operational related issues or maintenance issues such as roots, fat oils and grease, and debris. The other 9% of sewer overflows are greater than 1,000 gallons, and these low frequency, high volume SSOs contributed to 95% of the total volume spilled in the state. And the leading issues with these sewer overflows were capacity issues and structural issues. We have also identified in previous reports and during this the past fiscal year that 5% of the enrollees are responsible for 90% of the volume spilled in the state. The following two charts are going to go over some characteristics of those enrollees that are contributing to that 90% of sewer overflows in terms of the volume. This chart shows essentially the percentage of enrollees and the volume they contribute to that 90% of volume spilled in the state. And as you can see, enrollees owning 100 miles or less contribute to more than 50% of the 90% volume spilled in the state. I also want to mention that we provided a list of all the top 20 spillers in the state in the back of the annual report for the past fiscal year and since inception of the program. I also want to note that some enrollees that are in that list might have had a one-time high volume SSO that landed them on that list. Moving on to the next chart, this chart shows again the breakdown of those enrollees contributing to that 90% of volume spilled in the state, broken down by population served. And as you can see, enrollees serving 20,000 or less in population contributed to about 44% of that 90% volume spilled in the state. Moving on to the next slide. This slide shows a trend in the number of SSOs by month. And the lower line shows the number of SSOs reaching surface waters. The middle line shows the number of SSOs that didn't reach surface waters, and the upper line shows the combination of those SSOs that reached surface waters and those that didn't. And as you can see from this chart, there's a decreasing trend in the number of SSOs reported to the database. You can also notice that there's some correlation to the wet seasons. That's when you see most SSOs reported to the database.
But we'd still like wet seasons, wouldn't we?
In terms of the volume spilled by month, this chart shows a correlation between the total volume spilled in millions of gallons and the average precipitation in inches throughout the state. And as you can see, for specifically for the water year 2010-2011, we were at 135% of normal precipitation during that year. And as you can see, there's a significant correlation to how much volume was spilled throughout the state, which could be an indicative of some issues with inflow and infiltration throughout the state, and also structural issues.
Do you think, just a question, do you think that because many of your small systems are the ones that you're having, that are reporting problems, that it's simply old systems that have deteriorated, that aren't getting the upkeep that they need, or replacement?
We did an analysis of age and correlated to spill rates, and what we noticed is that those agencies that own 50% or more older than 52 years had twice as high sewer overflow rates.
And is that mostly smaller systems?
It's a combination of small and large systems.
Can you, on the December 10th, is that the big one that was in the Bay Area?
Yes. As you can see, during the past 2 years, we were at around 75% of precipitation. And as you can see, there's a decrease in those high volume SSOs that we experienced in previous years. In terms of what's causing SSOs throughout the state, we broke down all those causes into 4 categories. Operational, which relates to debris, fat oils and grease, and root issues. Condition relates to flow exceeding capacity, so issues with undersized pipes and rainflow exceedance. We also have structural and other causes of SSOs. This chart shows that the high number of SSOs are driven by operational or maintenance issues. 80% of all the volume of all the SSOs were caused by operational related issues. In terms of the volume, we see that what's driving those high volume SSOs are structural and condition issues. So rainfall exceedance, undersized pipes, and so on.
I really should ask Steve this. We'll put him on the spot. I know with drinking water, one of the approaches to try to reduce the amount of leakage from drinking water is to have the capacity to moderate the flow depending on whether it's night or daytime or winter or summer, because there are different levels of flow going through a system. If you're 24/7 pushing a system, you're going to get cracks in your pipes. If you have the capacity to moderate ever so often, I'm told that it improves the performance of the length of performance, the age of the pipe can last longer, and the overall performance. Is that the same? I would think it would be, but is it the same for sewers? Do you need to be able to control the amount going through on a regular basis, depending on what's the date, the time and the season?
I think the answer is